Most people know or have heard that they should have a will. Truth is, though, most people don't have one. And even among those who do, the vast majority are missing at least one of the 5 documents that actually protect their family when something goes wrong. And not having these documents doesn't protect your family from difficult decisions. In fact, in some ways, it actually guarantees them. Today, I want to walk through the 5 core estate planning documents that every adult should have, what each one does, who needs it, and what happens if you don't have it. Hey everybody, I'm Faustino Munoz. I'm a certified financial planner and a behavioral financial advisor here in Pensacola, Florida. This here piece of financial planning has nothing to do with investment returns and everything to do with protecting the people you love. So let's jump right into it. As we do though, I want to be clear up front. I'm a financial planner, not an estate attorney. A strong financial plan does plan around these documents that we'll go over today, but this video is for educational purposes. It will give you a clear picture of what these documents do, but creating them correctly requires a qualified estate planning attorney in your state. So the goal of this video is to make sure that you walk into that meeting knowing exactly what you need and exactly why you need it. A will is a legal document that specifies how you want your assets distributed after your death. It also designates who will be responsible for carrying out those wishes, your executor. And critically, if you have minor children, it designates who you want to serve as their guardian once you're gone. Here's what happens if you die without a will. Your state's intestate succession laws take over. In Florida, for example, those laws follow a specific hierarchy. Surviving spouse first, then descendants, then parents, then siblings. That distribution may or may not align with what you actually want to happen. More critically though, if you die without a will and you have minor children, a court will appoint a guardian. And that guardian may or may not be who you would have chosen during your life. And the court doesn't have to ask you because you didn't tell them. A will is not just for wealthy people to have. It's for anyone who has opinions about what happens to their stuff and their children after they're gone, which is most people. Document 2 is a trust. Now, a trust is a legal arrangement where you transfer ownership of assets to that trust, which you control during your lifetime, and specify what happens to those assets at your death. The primary advantage of having a trust, specifically a revocable living trust, over a will is that assets held in the trust avoid probate. Probate is the court-supervised process of validating a will and distributing assets. In many states, probate can take months to over a year. It involves court costs, attorney fees, and is public record. Assets that pass through a trust transfer to beneficiaries without probate. Faster, cheaper, and it's private. Now, does everybody need a trust? This is a question that I get a lot, and the answer is no. If your estate today is simple, your family relationships are uncomplicated, your assets are modest, and a well-drafted will, then, with beneficiary designations properly updated, may be sufficient. A trust becomes more valuable if your estate is larger, you have real property in multiple states, family situation is blended or complex, or if you have really strong preferences about how your assets should be distributed over time. The third document is a durable power of attorney. A durable power of attorney gives another person, your agent, the legal authority to manage your financial affairs if you become incapacitated. Sign contracts, access bank accounts, pay bills, file taxes, manage investments, things like that. Now the word durable there is critical. A durable POA remains effective even if you become mentally incapacitated. A non-durable POA expires if you lose mental capacity, which is exactly when you often need it the most. Without a durable power of attorney, if you become incapacitated, your family may need to petition a court for guardianship to manage your financial affairs. That process can be expensive, time-consuming, and emotionally difficult, all of which is avoided by a single, well-drafted document signed while you still have full capacity. Now, a healthcare surrogate designation, sometimes called a healthcare proxy, designates who can make medical decisions on your behalf if you now cannot make them yourself. Without this document, healthcare providers may be legally prohibited from sharing your medical information, even with your family. And if family members disagree about your care, there may be no clear authority then to resolve it without a document in place. This document here is particularly important for unmarried couples, adult children of aging parents, and anyone whose relationships are not automatically recognized under state law. The fifth document is a living will, also called an advanced directive or declaration. It documents your wishes regarding end-of-life medical care. Do you want life-sustaining treatment continued if there is no reasonable expectation for you to recover? What are your preferences regarding artificial nutrition, hydration, mechanical ventilation, or other medical interventions? This document doesn't speak for you after your death, but it does speak for you when you are alive but unable to communicate. Having clear, written, legally valid instructions removes an extraordinarily difficult burden from your family at the worst possible moments. The people you love should not have to guess what you would have wanted to have happened. You can tell them. And this here is how. One bonus estate planning document for you. I want to add one more item that technically isn't a separate document, but may be the most practically important thing that I'll say in this entire video. Your retirement accounts, life insurance policies, and many financial accounts pass to beneficiaries by way of contract, not by your will. Your will has no authority over who inherits your IRA. Your beneficiary designation does, however. If you designated, say, your ex-spouse as the beneficiary of your IRA 15 years ago and you haven't updated it, your ex-spouse inherits your IRA, even if your will says otherwise. Even if you've been remarried for 10, 15, 20 years at this point. So please, I ask you, review your beneficiary designations every time there's a major life change. If there's a marriage, a divorce, birth of a child, death of a named beneficiary, any of these, and review them at a minimum anyways every 3 to 5 years regardless, because it's very important. Well, there you have it, 5 documents: a will, a trust if appropriate, durable power of attorney, healthcare surrogate, and living will, plus current beneficiary designations. Most people have 1 or 2 of these in place and have checked on them recently. Few people have all 5 done correctly and have had them all recently updated. This is not a wealthy person's problem here. This is a planning problem for everyone, and the cost of not having it done is paid by the people that you love most, not by you. So if you don't have these documents in place, I'd encourage you to take the first step. I work with several trusted estate attorneys in Pensacola, and I'm happy to make an introduction. If you want, I do free 30-minute planning calls. The link is in the description below, and subscribe for more of this every week.